Well, good afternoon. They're working on my PowerPoint slide, getting it in the right mode. So that's why we're not starting right at 2 here. Or 1, excuse me, at 1. Or 2. Yeah. Yep, they're trying. Okay. Can we enlarge, are you able to make this box larger by just making this smaller? No. And you tried the slideshow tab, the fifth one over? Okay. Next one, 2 more over. Now the next one, that one, yep. Yeah, that one. Now go from the bottom, left. 1 more. That one, perfect.
That's what's on.
Oh.
You see this category right here where it says use presenter view? Click
Down.
that box. See if that changes it.
And then from the beginning? Hello? Great, thank you. Can we kill the music? No. Okay. Jeez. I don't know, 4 of us go somewhere. Hey, good afternoon. Most people, after hearing me in the morning, choose not to come back, so I'm always thankful. The candy probably helps, right? Yeah. Yep. Just being honest, Tim, the candy. Yeah. Hey, man, what's mine's yours. I'm just a manager of it. Yeah. So we're going to talk this afternoon about the basics of an estate plan. Just for some clarification, I am not an attorney, so officially, legally, I can't give you legal advice. I'm going to talk about just general concepts that are wise concepts that work in Washington State. And you can pause me and rewind me. Like I said this morning, you can't fast forward me a whole lot. But my time is probably about 25 to 30 minutes. And we'll go as long as we need for you to answer questions and ask questions and all that kind of stuff. So, are we good? There's a handout on your table. This handout is simply some of the slides, not all of the slides, but some of the slides that I'll be talking through. I also have cards over there if you want to follow up with me. Just one truth and transparency. I have not stolen your church directory, so I don't know really any of you. I don't know where you live. I don't know, frankly, your names. I don't know your addresses or your phone number or email, so I will not contact you unless you tell me to contact you. So don't be afraid that being here means I'm going to be haunting you for the rest of your life. That is not my intention. I'm here to be a resource, okay? And let me also just tell you how I'm paid. I am paid a salary by the covenant, so I'm not commissioned, so I don't get paid more or less for being here today. And we're a fiduciary, which is a fancy word meaning we have to do what's best for you by law. So that's kind of the background information. Really, I'm just here to serve you and tell you some ways to do things with the stuff that God has entrusted to you. So, are we good so far? All right, well, let's go. Let's go. The purpose of an estate plan is to distribute your money and worldly goods in a legal, and what's that next word? Orderly manner. Yeah. To distribute your money and worldly goods in a legal, but make it nice for your son, your daughter, your executor, or in Washington, your personal representative. Make it easy for them to get rid of all of your stuff. Okay? The purpose of an estate plan is to do this legally and in ways that you want it done, other than the state of Washington is going to step in and tell you how it's going to be done. Okay? Not that that's bad necessarily, but it might be different from what you would desire it to be. Okay? Let's keep going. If you want to stop me, just raise your hand or say, hey, buddy, stop. Okay? This is a cartoon. I didn't take it with me. I had it delivered. Yeah, that's not going to be the case, right? That's not going to be the case. Yeah. So why don't people have an estate plan? Wills and trusts are the primary legal or primary legacy planning documents for most people. We find many reasons for getting stuck, meaning not getting going on these documents. We think we don't need one, which most likely isn't true. We don't know where to start, which most likely could be true. They're too expensive. They might be if your situation warrants that. And frankly, attorneys cost more than probably most of us are paid. Or mainly we don't want to think about it, right? So I applaud you that you are here because you are dipping your foot into thinking about it, or you're saying, nope, by golly, now we're going to get after it because Tim's here, okay? 50 to 75% of the population die without having a plan, and I want to state from a biblical perspective what I stated this morning. What's yours is not really yours. What's mine is not really mine. It's his, and we're managers. We have a responsibility. So to me, to us, Covenant Trust, we have a responsibility to be wise with what the Lord has entrusted to you. No matter if there's lots of zeros or very few zeros, you need to be. We are responsible. Just like the parable of the talents in the Bible, right? The master gave gave 1, 2, and 5 talents to his servants, and the first guy's doubled it, the third guy didn't, and the master calls him a wicked, and what was the next word? Lazy. Let's not be lazy. We have a responsibility, okay? And that's why I'm here. Okay, let's play a game. Who's this gentleman? Abraham Lincoln, yes ma'am. Did he have a will or did he not have a will? No one look on your phone. You would guess yes. He did not. He did not have. I know he was. Yeah, he did not have a will. So Supreme Court justice had to step in and oversee his estate. Okay? Let's do the next one. Princess Di. Oops, I told you. Princess Diana. Will or no will? No, yes, no, yes. Yes, she did. I would guess they would require them. Yep. And guess what? Prince Harry and Prince William got a share, and her butler got a share. Okay? So it pays to be paid to be Princess Di's butler. Okay? Let's do this one. Who's this gentleman? Prince. Will or no will? No will. No will. Okay? His estate, before they found all the music that wasn't published or, like on his computer, was worth between $200 and $300 million. 45 different people have laid claims to his estate, meaning, I'm related, we were good friends. Okay? So 45 people. And guess how much money so far has been spent on legal fees to try to walk through this? Yeah, not quite 200, but 50 million. 50 million. Okay? So, yeah, Prince did not have a will. And how about this young lady? Who's this person? Amy Winehouse. Yep. She died without a will. Her estate was smaller than Prince's, $5 million, and her mom and dad got her estate. Okay, she didn't have a family, didn't have kids or spouse, so her mom and dad got it. Okay, so these are examples, some famous examples of people who both did and didn't have wills. Even so, they had the responsibility to put one together. Yes, sir. I don't know the intestate laws for whatever state she was in. Yeah, I don't know. Yeah, fair question. Yes, ma'am. So there are laws in the state of Washington that will give direction to a person's estate when there is no direction given by the person who has passed away through a will or a trust. So there are laws in place that will say, in this case, ding, 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 and that might agree with what you would want done, or it may not. But those rules would override whatever you would want, because what you wanted was not written on paper. Yep. Great question. Okay. And man, let me give you a high five. You must have seen my presentation. Without a will, the law decides for you. Okay? The law's going to say this is what happens, whether your kids, spouse, your parents like it or not. Okay? What do you need in an estate plan? So you need a will. I'm going to go out on a limb here and say every one of you in the room needs a will. Every one of you needs a health care power of attorney. And we're going to talk about these, so don't worry like, whoa, what's a will? We're going to talk about it. Each one of you need a financial power of attorney, and some of you may need a revocable living trust. Okay? You may need it. Okay? But you all need a will, you all need health care power of attorney, each of us need a financial power of attorney, and you may need a revocable living trust. And again, we're going to talk about those. Okay? There we go. Whoa. A will is more than a piece of paper. A will is your personal statement. Some people in their will talk about what they believe, what's important to them, and having done so, that helps their people named and the institutions named to understand why they're doing things in certain ways. Okay? A will is your final act. Okay? It's the way that you're going to be remembered, or it's going to impact how you are remembered. But we say often to people, if they are estranged from a son or a daughter, sometimes people have a tendency to want to stick it to their son or daughter one last time, and we want to really caution that. We don't want to what we say is we don't want you to legislate from the grave. We want to try to, a will is an opportunity for you to bring healing, to bring wholeness, to bring shalom in some ways that maybe was more difficult during your lifetime, if it's warranted. There are situations where you don't want to name people for whatever reasons. But a will is your final act. It does speak to your legacy, and it provides potential gifts and blessings to those who come after you. Okay? Let's keep going. So a will is the primary legacy planning document for most people where you direct, and this, I bet this has a pointer, doesn't it? Maybe not. Okay. The top circle, asset and personal property distribution. A will say, when I pass away, I want my estate to be given, we have 3 kids, a third to our kids, and 10% to charitable causes. A will direct where and who gets our stuff. Okay? A will have, if you'd like, any charitable component to it. What we say is if your local church, the Gathering House, if it's been important to you and your giving during your lifetime, could it not make sense that you make the Gathering House part of your final gift, your legacy after you've passed away? So a will would be the place where you would name the Gathering House or the YMCA or the mission downtown. You could name any charitable nonprofit in it. If you have children who are minors, a will is the place where you name who's going to get Johnny and Susie. Okay? When my wife and I had our first son, Luke, I was pastoring a small church, was getting paid like $30,000 a year, and my dad said, Tim, you don't have any money, but you have my grandson, my only grandson. You need a will. And so Deb and I got a will where we named the right persons to be Luke's guardians if my wife and I passed away. Now he's 24, and those rules would not apply to him. If your family has a special family situation, a will could give language to that. Perhaps a family situation would be you have a child who's special needs, autistic, or you have a child who is a spendthrift. It would not be wise for them to receive money in a lump sum. A will could create a trust or have provisions that give language for distributions in future years. So if you have one of those situations, a will could be involved in that. And a will names who your executor, or in Washington, who your personal representative is. That person who is responsible for gathering the assets and then distributing them according to what the will document says. Okay? Those are 5 themes, 5 things that are often in wills. Are we okay so far? We're going to begin to unpack this a little bit more. Yes, ma'am.
Our daughter's now 18, and I'm wondering if I should change the language in the will because now she doesn't need a guardian.
Perhaps, if you passed away today, potentially she could inherit her share of your estate at 100% or whatever percentage is, and if that's a wise thing for her to receive that much money in a lump sum, maybe you don't need to make a change. But if that's an unwise thing, maybe you should put some wording that would control distributions to her. Mm-hmm. Yeah, that's a great question. Keep going. Yes, sir.
Can you talk a little bit about, who will take children, young families, and how do you think about your estate given the young children? Because they're going to need to be financed.
Yeah, great question.
How do you make sure whoever takes them doesn't squander the finance?
Yeah, great. So let's talk about that. I have learned in this role that it may not always be wise, sometimes it is wise, but sometimes it isn't, to name an older or younger sibling to be guardians of Johnny and Susie. Sometimes it makes sense to name a family member or a grandma and grandpa. Sometimes it doesn't. Sometimes it's better for whatever reason. I'm not here to judge. It's your responsibility to name the right persons, to go outside the family to be guardian for Johnny and Susie. If you come to me, this is going to be blunt. I don't mean to be blunt, but if you come to me asking who should be guardian of your child, you're kind of like, I don't have a clue, right? You know. And if you don't have that person, then what we say is begin to cultivate those relationships. Like, this is part of your responsibility as a parent, to try to be in those relationships, grow relationships with people, to discern if they might be good people who could step in to be guardians of your kids. Sir?
Also, the person you have as a guardian is not to be the person who holds the purse string.
Which is where I'm going next. Yep. So that was the guardian piece. It can or can't, maybe it can make sense, or maybe it doesn't make sense for that same guardian to be in charge of the purse strings. Maybe it does, maybe it doesn't. It depends on your person. Oftentimes what we see, and a role that we can play, if you want us to, is that we are a trust company. So some parents say, we have 3 small kids, we're going to name Brad and Heidi to be guardians of our kids, but Brad and Heidi cannot do money very well. So Tim, we want Covenant Trust to oversee this trust fund for the benefit of our kids that Brad and Heidi have. And you have written provisions in your document that talk about the reasons for distributions for your 3 kids. Typical distribution language is in 4 categories. HEMS. H stands for health. Tim, the trust can pay any health expense for my kids. E is education. Tim, the trust that we set up for our children can be spent on educational endeavors that our son and daughter might have. M is maintenance, and S is support. What is maintenance and support? Well, it's purposefully vague, which would allow the trustee to determine if what Brad and Heidi are asking for the benefit of your kids is in their best interest. If Brad and Heidi come to Covenant Trust and say, our new kids need a Ferrari at 16, we would say that is not maintenance and support. We would say a Ford is maintenance and support. Okay? That's a gross example, but what we say is, or typically the way we advise people is use the HEMS standard, HEMS, and allow Covenant Trust to be the trustee of the money and to discern whether that's a good request, legitimate request or not. And when it is confusing or when there's a lot of question, we have a review committee that will handle each request individually to try to discern, as a fiduciary, meaning we have to do what's best for your surviving kids, what's best for them. So, did that kind of make sense?
Yeah, I guess part of it was just in my mind too. I could imagine a young family saying, our 2, 3 kids are not going to go with my sister, my brother, my whatever.
Yeah.
Now, sister, brother say, well, then we have to buy a bigger house.
Yes. Oh, great.
So they take the estate
Yep.
to buy a bigger house with more bedrooms, but who owns the house?
Yeah.
Does that all work out in the wills?
Yeah. So,
How is that all laid out?
yeah. So, potentially, it depends how the document is written, a larger house could qualify, not a mansion, for maintenance and support. Suddenly, our household went from, I don't know, mom and dad and 2 kids to a mom, dad, 2 kids, plus 3 more. So we, Covenant Trust, would say, yes, we will provide money for you to buy the larger house. And potentially, we could provide you with the $2,000 a month in more expenses for milk, bread, dentists, haircuts, tennis shoes, whatever. So there's this ongoing reality of raising kids that would typically fall under maintenance and support, and we would provide distributions for the new guardians. Yeah, great question. Yes, ma'am. Right. Great question. Yeah. So sometimes, depending on the thing, we ask for their reimbursable expenses, like show us the receipt. Sometimes they're not. It kind of depends. And sometimes, if we have questions, it might elicit us to go and visit the household, the kids, to kind of give a look in, a look and see. Sometimes what we've found is that, like in a faith community, if these guys had 3 minor kids and they passed away, and you got the 3 minor kids, and these guys felt that you were I'm sorry to pick on you. If they felt that you were misappropriating funds, it's not uncommon, or actually it is uncommon because most of our clients aren't this way, right? But there have been times where these 3 have said, hey, we're going to talk to Tim because there's something fishy going on here. And so that triggers us to look more deeply into it. But we're not a policeman. We're not, Rob asked for $20. Were the Nikes $21 or $19? You know, we're not gonna do that kind of monitoring. Yes, sir. So some people say the people we name as guardians can do all the money stuff as well. That's fine. And some people say, no, we want it differentiated. And it depends on your situation. So, yes, sir.
So in a case like that, if they were part owners of the family, then said, well, if you're out of the house for yourself, they would get some of that money back if they were part owners.
Yeah. Yes. Yeah. Mm-hmm. Yep. Let's keep going. And probate, and probate is the court process by which a will is proved valid or invalid, and it's the legal process by which property is transferred after death, required if assets are over the small estate limit. Let me unpack this. So if you have a will and you have assets, your estate is going to go through probate if it is larger than $100,000 in Washington state. Okay? If it's smaller than that, the executor, the personal representative, can file what's called a small estate affidavit, and then the estate does not have to go through probate. Okay? So in the probate process is the process of just overseeing that what you have on paper is indeed being followed by the personal representative. Okay? This is not meant to be judgment, but it's kind of judgmental. To me, most government processes take longer than they should and cost more than we think they should. I have been told, though, that by attorneys on the west side of the state, that in Washington state, probate is fairly straightforward. Fairly straightforward and moves fairly quickly and is reasonable price-wise compared to other states. Okay? That's what I've been told by attorneys. Yes, sir. Or ma'am. Great question. And maybe that's a transition to this slide. No, it's not. So, great question. It's going to be coming up. Accounts that have beneficiaries named on them. What are some accounts that have beneficiaries named on them? Life insurance. Some of you have IRAs or 401ks. Some of you have annuities. Some of you have transfer on death designations on accounts. Those do not count towards the $100,000, which is, I believe, your question. So if your money has a place to go through beneficiary language, transfer on death designations, through different titlings, those accounts, those funds do not count toward your small estate $100,000. So it is possible, friends, for your estate to be worth $1 million, but every one of your accounts, even your house, has a transfer on death deed to it, and there's a good possibility that your estate could then file the small estate affidavit because the accounts that you have no beneficiaries on are less than $100,000 in value. That's an important question. They are not subject to probate because the various institutions that handle those accounts, the 401k people, the IRA people, the life insurance people, when they find out you've died, they're going to send that money to whoever you've named, regardless of probate. Great question. And that's going to be a slide here coming up. It is a strategy. It is a strategy. Absolutely. But this is where it can catch up with people. Some people get so good at telling their money where to go when they die, meaning beneficiary language and transfer on death language, that there's no money left in the pot to pay the estate taxes, to pay any final medical bills, to pay the final credit card bills. If they died in a car accident and the estate is being sued, if all the money has a place to go, there might not be money left in the pot to cover those costs. So it can be a double-edged sword. Okay? Yeah, I know. Yeah, it gets. I'm not. Chris, do you know the answer to that? I think they have to go back and ask. The estate needs to go and reclaim some of that to pay the bills that the lawsuit, the taxes, the whatever that are left unpaid. So, walking out of probate court. So wills. Probate is a public process, so I can't believe she left everything to that stupid parakeet, right? Like, what in the world were they thinking? You know. It was the next slide, assets that avoid probate. So if you have joint tenancy, meaning rights of survivorship with your spouse on an account, that avoids probate. Washington State is a community property state, so if you're married and have a community property agreement, your spouse would get whatever assets there are. Trust assets avoid probate, and we're going to talk about those in a few minutes. Assets with designated beneficiaries, I've mentioned IRAs, 401ks. 403bs are a 401k for the nonprofit world. Life insurance annuities and bank accounts with payable on death. All of those types of accounts avoid probate. Okay? So a take-home for some of you could be, maybe should be, what are your accounts and how are they titled? And could it make sense that you put TOD designations on them, or at least look into who you have named as beneficiaries to make sure they're going to the right people? Because the beneficiary page is going to trump what the will says. Let me give you a good example that's tragic. If you were previously married and got divorced and you never updated the beneficiary page from your previous spouse to add your current spouse, guess what when you die? It goes to the previous spouse that you have been divorced from. Even though the will says, give it to my current spouse. The beneficiary page trumps what the will says. That's an important piece. Make sure your beneficiaries are accurate. Okay? Can we keep going? All right. I'm like, for assets of the designated beneficiary, update beneficiaries at least annually. beneficiary designation or payable on death is not a substitute for an estate plan, which was your point, Dale. It's probably wise, it is wise for you not to have direction for every cent of your estate through beneficiary pages. There needs to be some assets left in your estate to pay the final bills and taxes. Limitations of a will. It's only activated at death, meaning, this is my will, and it's only good for when I die. Okay? It lacks privacy, which means it becomes a record of the courts, so you could snoop to find out who got what. There's the cost and the process of probate, potentially. So those are some limitations of wills. Okay? So that's one type of an estate planning document. Are we kind of okay? You're a good group here. Anybody need some candy? What's mine is yours, and I'm just a manager of it. Yes, ma'am.
If your estate is in a trust, is it touchable? Touchable as far as, like, say, I don't know what I'm trying to say, sorry. Like you said, the estate has to have enough money in it to pay bills. What if your estate, is that your house part of that?
Your house is considered part of your estate. Mm-hmm. So if you put your house in a trust, is it protected from like any liens or debts or whatever? Let's go through the trust slides, and then let's come back to that if it's still foggier out there. Okay? Yes, ma'am. Yeah. So that $100,000 also includes your personal possessions: cars, paintings, couches, TVs, boats, ATVs. So for a lot of people, it's probably not practical to think that your estate is going to be lower than $100,000 in order for the personal representative to file the small estate affidavit. Because we have cars, we have couches, we have some other C words that I can't think of. RVs, yeah. What I tend to say is maybe $50,000 of, I'll say, cash or money to pay those final things. I don't know if that's the right amount. I don't know. Yeah. Because we don't know. If I die today in a car crash where I slip on ice and hit a tree, no one, well, maybe someone's suing me, but no one's probably going to sue me. But if I'm in a car crash today and die because I hit another vehicle and it's my fault, oh, good golly, Miss Molly, it might cost millions of dollars. So I don't know. Yeah. Yes, sir. Yeah. And if that $50,000 got paid out, then it's maybe the house is next. Or I don't know the order of things, but the personal representative would have to figure out what are the assets left and how do we liquidate those to pay for whatever the expenses are. Okay? So what's a trust? This is another type of an estate planning document. A trust is a legal agreement between a grantor and a trustee. I'll explain that in a minute. It distributes assets and personal property. It is for the benefit of beneficiaries today and tomorrow. and it's completely changeable and amendable. Okay? So let's begin to talk about this. This is my trust. Or actually, let's use this bucket. Let's use this. A trust is a legal agreement between a grantor and a trustee. This is my trust, Tim's trust. My trust creates a bucket, a bowl, into which I can name assets. I'm the grantor, meaning I grant to put. I'm going to put this asset into my trust. So no longer is this asset owned by Tim. This asset, I'm the grantor. I'm granting that it comes into my trust, and now it's not Tim's Reese's cup. It's Tim's trust Reese's cup. And I granted that happened, and I am the trustee. So I oversee what goes into my trust and how it's being managed. And I can name my house into trust. I can name different bank accounts into trust. I can name many other things into trust. And no longer does Tim own them, but my trust owns them. Okay? And I am the grantor and the trustee, meaning I am responsible for that which is in my trust. And I might say to me, distribute assets to me while I'm alive. Meaning, I might call my trustee and say, every month I want you to send me 2 M&Ms a month, or $2,000 a month. And the custodian sends me $2,000 a month from my trust so that I can put gas in my car and eat out lunch at the Shenanigans or wherever we went for, that place for lunch. That was really good. So a trust is for my benefit during my life potentially. What I see is if one spouse does all the money in their relationship and the other one doesn't, often trusts are set up because if spouse A dies who does all the money, a trust can be set up so the trustee who oversees the trust can look after that surviving spouse. And covenant trust is in the business of being trustees on people's trust, where people name us as a successor trustee to oversee this when they can't, when they don't want to, or when they're just tired of being trustee. They say, hey, Tim, you guys take over and fulfill what the document says for our benefit, but then also after we die to settle out our estate. Okay? And you can decide to say, oh, that was a dumb decision. We want to amend that trust. Or one of our children's situation has changed. We want to make another change. Or we might say, our life has become more simple now. We no longer, we emptied that account, and that account, and all we have left is this one account. A simple will is sufficient. We don't need to have a trust anymore. You can revoke your trust and say we don't need it anymore. It kind of depends upon your situation. Let's keep going, and we'll keep unpacking this. Are we okay so far? So you can be a grantor and a trustee of your trust for the benefit of you during your lifetime. When you die and your spouse remains, and once your spouse dies, you can have the trustee overseeing your trust for the benefit of grandchildren or even your own children. In family situations, we often see this. The parents say, our clients say, we want to establish a trust for our kids and grandkids that's going to last long after we've passed away. And Tim, we want you guys at Covenant Trust to oversee this for the benefit of our kids and grandkids. Okay? And that's what we do. Sir. Great question. Yeah. So the way that would work, and we see this all the time, is we would work with, and we haven't gotten there yet, we would work with your health care power of attorney, that person who's responsible to speak for you when you can no longer speak for yourself. We would work with him or her to care for you. That health care power of attorney would be making the medical decisions on your behalf, and the financial power of attorney would be contacting us to say, pay Dale's bills out of the trust, or these are Dale's bills. Can you review them and pay them? Yep. Great question. Absolutely. Because we work with the people that you have named, and we trust the people you have named to be trustworthy. Yeah. Yep. Let's quickly compare wills and trusts. Wills are only activated when you die. They lack privacy, and they go through probate. But trusts provide financial management if and when it's needed. They control over assets being distributed. They avoid probate and the delay of probate. Did I mention that? Any asset in a trust avoids probate? Did I say that to you? Okay. So if you have an account that's titled into your trust, that asset avoids probate. Okay? They can be in the trust, but most often they are not. Though sometimes assets that have beneficiaries, they name the trust as a beneficiary so that the trust is then funded for it to look after you, spouse. Yep. Yes, that's not uncommon. I mean, there are tax implications, depends upon a person's situation, but that's not uncommon. Great question. And trust can add provisions to reduce estate tax, though the state taxes numbers are so large now, it doesn't affect most people. Yeah. And trusts, anything you name in a trust is private. Now let me tell you reality. You walk out of here today going, honey, sweetie pie, whatever you call that person in your life, and you determine you need a trust, and you go to the lawyer and you have a trust drafted. But all your accounts remain titled as they are now. Meaning you haven't changed the title to Tim's trust owning that account. In that case, this trust, though it's a legal document, having been written, it is completely unfunded. So all of your estate would still have to go through probate because you during your life put nothing in your trust bucket. Does that make sense? So it's important that if you have a trust, that you fund the trust by I like to say simply. Sometimes it's more complicated than it should be. The institutions sometimes drag their feet. By renaming your accounts into your trust so that your trust owns them. In the case that you didn't fund the trust or you forgot to name certain things into the trust, you still have a will with a trust, but it's called a pour-over will. And a pour-over will simply says this: anything that I haven't named into my trust, the will gathers it up, scoops it up, and through probate, it gets poured into the trust. So eventually, your whole estate will end up in the trust, but it'll have to go through probate to get there. Okay? Did that make sense? That can be confusing. Are we okay? It's better for your personal representative for you to have gone through and renamed your accounts. Yeah. Yes, sir. Exactly right. Exactly right. exactly right. An individual or the covenant? It's owned, oh, the couple. It's owned by the trustees of that trust. Correct. Yeah, yeah. And we can get in the weeds really quickly, right? So it's quite common that people would name a house into their trust. Most of our clients do not name cars into their trust because most of us drive Hondas, Fords, and Toyotas, and they're not, I mean, we think they're of great value and significance, but they're kind of not. And other accounts like IRAs and 401ks, in some situations it does make sense to use those to fund a trust. In other situations it may not. It kind of depends upon what you're accomplishing, how much money you have, and how you want people to receive it. Yeah, I didn't quite get that out of your question. A trust cannot be it's going to be your name on the IRA or your name on the 401k and not Tim's Trust IRA. It's never going to say Tim's Trust. It's going to say Tim's IRA, but not Tim's Trust IRA. Yes, sir. Yes, sir. Yes, sir. Okay. When you create a revocable trust, you say 4 things to the trustee. Here are my assets, manage them for me according to my direction. Make payments to me from this trust as I direct. Thirdly, if I become unable to look after my own affairs, Dale, this was your question, I think, take care of my financial needs and those of my spouse and my dependent. And thirdly, when I pass away, continue to manage these assets for my spouse and dependents or distribute the assets according to the trust agreement. Okay? Quite common, if you're married, for you to be a trustee and your spouse to be the trustee, and the trust document is going to have language say who is your successor trustee, meaning if you can or don't want to, who's going to be that person or corporate trustee to oversee the document. Okay? And that's the role that we play. Okay? And I think we're going to get to that now. So your trustee carries out the provisions of your trust. It could be a family member, a friend, or an institution. Choosing a trustee is one of the most important decisions you will make in your financial planning. So who is that person that's going to be in charge of that bucket of assets that you have named? Okay? And we make the case, this is our business, for you to certainly consider naming Covenant Trust as the overseer of your trust. Let me go through these reasons. Does the named individual have experience with trust settlement? If you name your son or your daughter after yourself, do they know how to do this stuff? Do they have experience settling an estate? Do they know trust taxation? Are they aware of liabilities that could come upon them or the estate? Are they able to tell certain beneficiaries no? Like if there are children and one child doesn't like what mom and dad said, is the trustee able to tell that guy or gal, sorry, I know you don't like it, but what we say is we don't sit at your Thanksgiving table. We don't know the family dynamics. Our task is simply to do what your trust document says, no matter if your son, daughter, grandchildren like it or not. We do what this says. And we make the case, let your kids be kids. Families are messy enough anyway. Often this kind of conversation makes things muddier. We think it could make sense to name a corporate trustee to oversee your trust for the benefit of the people named. Sir?
Is that after the passing of the last spouse?
The question is, could covenant trusts step in as trustee before the passing of the last spouse or before? It depends upon the situation. Some people resign as trustee in their lifetime and name covenant trust as trustee, and sometimes it happens after they've passed away. Great question. Yes? Fee question, great question. We charge, what's the cost of this? Is the question. Yeah. Right. Yeah. So we charge, Covenant Trust charges 1.25% annually on trust assets. That's what we charge. So on $100,000, we charge $1,250 annually to be in the role of trustee. Okay?
So if having a trustee is, another trustee isn't absolutely necessary, you can put a trust together, you're the grantor, and you are the trustee. Perfectly fine. All right? When you might want a corporate trustee is after the last spouse passes, because during your lifetime, if you create a trust, you're the grantor, everything, can I borrow that little bulb just as a picture?
Yeah, of course. Do you want this one?
No, but both of them actually. If you're the grantor of the trust and it's a revocable trust, it's a look-through trust. The IRS sees what's in there. You own it. It looks through it. There's no protection in here. So whatever's in here, like your house, will be attached to this suit. But if everything in here is going to bypass probate. A revocable living trust is a look-through trust. Everybody can see what's in there. You can manage it. You can do your own taxes. Your tax picture does not change when you create a revocable living trust. After you pass away, you may want to have some protection from your kids in case something is sued. Then you put it in a trust that goes to the kids. No one can see what's in there because it's not in their Social Security. It doesn't follow them. It's an irrevocable trust. The kids don't own it. It can't be sued. It can't be bankrupted. No one can come after it. So there's not necessarily a need to pay the 1.5% during your lifetime because your tax picture doesn't change. The ownership, even though it's in the name of the trust, it's looked through, so you still own it. You can buy a new house, sell this house, it doesn't matter. It's looked through, but it's going to bypass the entire probate system. And it's going to follow whatever instructions you have after your death. Okay? After you pass away, that's when things start to become important. A surviving spouse may not be the best person to manage assets after spouse A dies. At that point, it might make sense for wifey to have a corporate trustee, and so she doesn't have to worry about taxes, distributions, and covenant trust. It's now an irrevocable trust that she's the beneficiary of. Then you're paying the 1.5%.
1.25.
1.25, but you know that spouse who might not be great with money is going to be well taken care of, and then everything in here is protected.
And we don't charge that 1.25 until we step in the role of trustee. So you can name us as successor trustee, but until we step into that role of trustee, there's no fee because we're not doing anything for you. Pardon me?
That's a wonderful thing. Name them now, so it's in there.
Yes, you want to have named a successor trustee in the event that you need them. And again, we don't charge anything until we begin to do stuff for you in that role. Yes, sir.
Sorry to come back to this, but I have some experiences in my past. So, if my wife and I are co-trustees, and you're the successor,
Mm-hmm.
my wife dies, I go potty, and I'm not there mentally,
Yes, sir.
I have to either tell you guys that I'm giving it up, or somehow I have to declare it incompetent.
Or your financial power of attorney person has been granted those powers to make those decisions for you, and they come to us and say Dale and Patty are no longer have capacity.
Because otherwise, it's like, hey, send me all my money, I want to buy for
That's correct.
So
Yeah.
you're protected in that way
Mm-hmm.
by your financial
Power of attorney. Yes, sir. Okay. And we're kind of talking about this. You know, why? This is not, remember, I'm salary. I'm not trying to get anything from you. If this is helpful, this is what we do for people. Why would you consider Covenant Trust? We're a third party. We don't sit at your Thanksgiving table. We just do what your document tells us to do. Okay? We don't know the family dynamics. We just do what mom and dad said. Okay? We have knowledge in this, experience in this. We have no self-interest. We have the ability to say no to Ferraris and sometimes Ford Raptors and say, no, you get a 150 and not a Raptor. We have to abide by laws, option, yeah. And we can serve as a successor trustee initially. Okay? Okay, so we've talked about wills and trusts. Let's talk about these POAs that I keep circling back to. A financial power of attorney is a role that should be part of your plan that says, I'm Tim, and if I am alive but don't have capacity, I name my wife Deb to serve in that role. If she has passed away or doesn't have capacity, then I'm going to name a third person who's going to step in and make financial decisions for me. And in Dale's most recent question, that person could contact Tim and say, Dale and Patty don't have a capacity. Covenant Trust needs to step into the role of successor trustee. So the financial power of attorney can talk to Social Security, banks, where your 401k is, mortgage, credit card, I don't know, anything with money, that person is going to speak on your behalf while you are alive. That role ends, though, at your death. Okay? At your death, the personal representative / executor speaks on your estate's behalf. You can name the same person to serve in these roles, but sometimes people say, no, the financial power of attorney is going to be person A, and then there's going to be another person to be the executor or personal representative after we die, or after I die. Okay? And another POA is your health care power of attorney. It's the same thing. This is a person you name when you don't have capacity to make health care decisions for you. Okay? This power also ends when you die. Okay? Because there's no more health decisions to be made. You're dead. Okay? And the personal representative / executor makes decisions at that point. Okay? Great question. Can the same person be both financial power of attorney, healthcare power of attorney? I might even add personal representative. Yes, yes, yes. Depends on the family situation. That's a lame answer, but it's the truthful answer. Yeah, 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 yep. Some of, yeah. Yeah, burial expenses. So that would come out of the estate, one of your checking savings accounts. Before anything was paid out, those expenses would have to be paid. Mm-hmm. So we say it could make sense for you to have prepaid funerals all done, meaning you've chosen the casket, you've paid for the services, it's already paid for. All you have to do is die and show up, and it's all done. So your kids don't have to go through and say, $10,000 casket or $7,000 casket or whatever it is, or a cremation or whatever. So it can make sense to have a prepaid. Okay? Are we okay? All right. What else do you need to do? You need to review your documents, your estate documents, and update them as your situation changes. I'm guilty of this. Our will still, our only will is assuming our kids are all minors, and they're not. Our current will says they do not get lump sums, but at the age of 25, I'm making this up now, I don't quite remember. At the age of 25, they get 25% of our estate. At the age 30, they get another 25 and on. Because we were concerned, we didn't know the money habits of our children. Now we know the money habits of our children, and my wife and I, when we meet with the attorney, will have a will drafted that says they each get lump sums when we die, because they're good with money. We don't want to put the restrictions on them. But when they were 2, 4, and 6, who knew how they would do with money? But now we have full confidence that they would be wise, or they would learn really quickly not to be dumb. So, but we believe they would be wise. And our firstborn would keep number 2 and number 3 in check.
If you have a retirement plan and you want your child, your minor, to inherit that, and say you have a revocable trust, would you want the beneficiary of that retirement plan to be the trust, to manage it for the child? Because otherwise, would it just go to the child?
So when you name a minor on a, did you say 401k or IRA? Yeah, they're essentially the same. That child cannot have access to it until they're of legal age. So it's not like when they're 7 they can withdraw it. They're still under the guardian's jurisdiction. That's not the right word. They have to listen. The guardian's in charge of those decisions. And then, depending on what the trust might say or how the beneficiary is set up, who knows what could happen? What would happen would be determined by what you have said in the document, I guess would be the way to say it. Yeah. Sir? Okay. So this is the stuff we do for people. We manage money for people. You don't have to have a will or a trust for us to be money managers. We're money managers like, I don't know, Wells Fargo or Edward Jones or Thrivent or Fidelity or Vanguard, Charles Schwab. So we manage money for people. We manage money in IRAs for people. It's not uncommon for y'all to have maybe a number of 401ks from previous employers, and you want to roll them over into a single IRA. We do that all the time for people and manage money. We manage $2 billion in Chicago. We have over 4,000 clients. This is what we do. We offer these trust services, which we've been talking about. We help people think through their estate plan. And for people who have charitable intent, we help people to think through the best way to give money from a tax perspective. Tim, we have this desire to be charitable to the Gathering House maybe or other places. These are our accounts, and we sit down to determine what might be a good strategy to accomplish your charitable desires, giving from maybe choosing a account to give from, or multiple accounts, or create a strategy over time to fulfill your charitable desires. So we sit down with people to talk about gift planning. Okay? And our goal is to make sure you have the estate plan that meets your needs now and in the future, gives you some peace of mind, and takes care of that which is important to you. Okay? We are owned by the Covenant Church denomination. We are owned by the Covenant's College and Seminary, and we are owned by the Covenant's retirement communities. Those three nonprofits are the three owners of Covenant Trust Company, with having the desire, having the mission that we serve people within the Covenant denomination well when it comes to estate planning. And I'll say originally with the hope that y'all would be charitable primarily to your local church, that you would consider your local church in your estate plan. If this is a place that's valuable to you in your life, would it make sense for you to give them a gift so that could be part of your legacy? So, and with that, that was an hour and well, I guess we started a little bit late, so maybe about an hour. Any group questions? So what I have over here is, well, Chris, you spilled all my mints. General flyer on us. I have my business card here. If you do want me to contact you, remember, I don't know any of you really. If you do want me to contact you, fill this out and give it to me, and I'll be in touch. Otherwise, thank you for giving up an hour and 10 minutes on a Sunday afternoon. Yes, sir.
Could you just revisit real briefly a simple will with probate avoidance measures that anyone can put in place? A simple will with probate avoidance measures, just make sure if something happens that there's written instructions for everyone.
I think what you're getting at is if your estate is not overly complicated and the distribution of your estate is fairly straightforward, divided equally between child A and B with a charitable piece, perhaps that could be accomplished through designations on beneficiaries, or excuse me, designations on accounts that have beneficiary language. And if a lot of your assets and a lot of your intention was carried out through accounts with beneficiaries, there would be the potential that your estate would not go through probate and therefore be settled fairly straightforwardly. Is that a word? Straightforward. In straightforward ways. Is that what you were getting at? Yeah. So I would review how your things are titled, who's on the beneficiary, and then talk to those people, or you can call me and say, this is what I want to do. Does doing it this way make sense? And that's a conversation. It's kind of hard to have these conversations in a group of 20 when there's 20 different families here, if you will. Sir. The accounts that have named his children on them, the children get that account. The account, well, that particular account, I believe you said your mother's late husband had children that he named on a beneficiary account? Oh. Home. if they put a land transfer title on that home and he named the kids, then whoever he named on that title would get the house. But I don't think is that the case in this instance? Oh. Oh. Yeah, yeah, and admittedly, the attorney would be the attorney knows the full picture, and I know 30 seconds. I wouldn't want you to go back to your attorney and say, there was this guy at church that told me in 30 seconds this is the way it should be. It's free legal advice, and I'm not an attorney. So I would listen. I would talk to your attorney, or I don't know anything about your attorney, or maybe another attorney to get some perspective. Yeah. It's more messy than 30 seconds from a guy who doesn't know anything about that situation to really comment. Go ahead.
If we call you, will you help us go through and decide which picture works best?
Yeah. And I have people in Chicago, if it's too complicated over my head or I have questions, I 1-800-CHICAGO. There's 45 of us at Covenant Trust, so we have conversations about these things with individuals. Yes. Yeah, Washington state tax is at $2 million. So if your state's less than that, you don't need to worry about it. Federally, it's $12 million, 12 something. I don't know. My estate's not worth $12 million, so I don't really know the $12 million and whatever. So for most people, frankly, it's not trusts are not a trust. There's no reason. Estate tax is not a reason to have a trust for most people. That's what I was struggling to say. Yeah. 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 I guess this is not meant to be flippant. The grace period ends when you die. So you would want to get after it to get things. If I got divorced, I would want to, after that divorce goes through today, tomorrow, I want to update my beneficiaries away from my ex-spouse and name my kids or name my brother or whatever the situation. Otherwise, she's going to get it. So there are some things that you need to, it would be prudent for you to get on right away. Other things, it may not be as prudent for you to get after. That's kind of a lame answer, but I think that's the right answer. Okay, I want to be respectful for those of you who do want to get home and take your nap. You can go, and I'll stick around for a little while, but I do need to get to Nelson. I need to leave here within 20 minutes so I catch the border before they shut down the border so I can see my wife up there. So, hey, thank you. It's been fun to be with you today. And what's mine is yours, and I'm just a manager, so please take this. Candy. Yeah.